The topic which we are going to discuss today is on problems and prospects of rights of tribals and indigenous people in India. Introduction. India is a country with vast traditional, cultural, linguistic, religious and ethnic diversities. Population as recorded by 2011 Government of India census is 12.10 crores, in which 6.23% and 5.87% are males and females, and that of scheduled tribes is 8.6%, that is 1.04 crores. A large section of population which does not fall to the hierarchy caste group solely determined by birth consists of the tribals or indigenous people. Our country is the home to the largest population of indigenous peoples in the world. However, they are socio-economically and politically marginalized. As a result, they are driven to political extremism. Definition. The word tribe is nowhere defined in the Constitution of India. However, Article 342 declares that scheduled tribes are the tribes of tribal communities which the President may specify by notification. These groups are presumed to form the oldest ethnological sector of the population. The term Adivasi has become fairly popular. It is synonymous with the indigenous people who are further classified as a son of the soil with the epithet Adi, meaning ancient or original or first settlers. The other terms are Vanjati, Vanbasi, forest dwellers, Pahari, hill dwellers, Adimjati, original inhabitants, Janjati, folk people, and Anusuchit Janjati, scheduled tribes. There are about 622 recognized tribes in India. Now let's see constitutional safeguards. Article 46 of the Indian Constitution states that the state shall promote with special care for education and economic interests of the weaker sections of the people, and in particular of the scheduled castes and tribes, and shall protect them from social injustice and all forms to social exploitations. Articles 330, 332, 335, 338 to 342 and the entire 5th and 6th schedules of the Constitution deal with special provisions for implementation of the objectives set forth in Article 46. These provisions need to be fully utilized for the benefits of these weaker sections in our society. The tribal settlements are mainly centered around northeast region as well as the highlands and plains of central and southern region. About 80% of the tribes have their abode in central and southern plain regions. These differ from the northeastern tribes in ethnicity and in having experienced greater intrusion of the mainstream and the pan-Indian model of the state, society, economy and culture. Now we are going to discuss on denial of rights. In pursuance of these constitutional safeguards, the state has created a massive socio-economic welfare structure, subsequently subsumed under planned development efforts through 5-year plans. But it is on record that many communities have suffered on account of denials of such rights. Relating to this is the much talk about the Land Acquisition, Rehabilitation and Resettlement Bill, in short LARR 2011. Moreover, the social impact assessment, in short SIA, is not justifiable for a purpose welfare state. Therefore, the social reality assessment, in short SRA, would be carried out before harming the citizens of our country. In such manifestation, the overall programs initiated with bills or acts by the Government of India are found to be not compatible in the Northeast India although certain safeguards are already given with due consideration since the then Bardoloi Committee. The normal administration is in fact causing havoc in the lifestyle, tradition, culture, custom, and customary laws, and above all, to the economy of indigenous people. The contents of the said bill seem to ignore the Northeast people in general and tribals in particular. The significant impact of this step has been on tribal land holdings. This was compounded in the year 1950s by declaration of larger tracts as reserve forest, leaving the cultivators without proper records of rights at the mercy of the forest officials. Thus, the work normally carried out in the name of development is in fact the non-recognition of indigenous people's right to control and manage their own lands and resources. Thus, before the implementation of such developmental project, free and prior informed consent needs to be taken from the people. Our government is yet to acknowledge or accept the international framework for compatibility of space embodied in International Labour Organization Convention number 169 on Indigenous and Tribal Peoples 1989 and the United Nations Declaration on the Rights of Indigenous People 2007. Therefore, immense miseries are caused to the people of this region. The problems of tribal and indigenous peoples are increasingly supplemented with constant negligence or delay on the part of government to initiate development process and implementation of development programs at par with implementing the same developmental works in the area of the same citizens. For instance, to cite negligence out of many is that of Maui's problems or issue which the nation is facing today. It is nothing but a byproduct of the government machinery itself, as it was a result of prolonged negligence to their genuine demands relating to payment of compensation for the cost of their assets and properties before starting the process and acquisition or occupying their homestead lands forcibly. Another factor is the failure of the government to bring developmental schemes and projects implemented effectively in such tribal inhabited areas. The prevailing scenario arising out of the protracted negligence to their genuine demands and delay of such welfare programs to the tribal and indigenous people have ultimately resulted in demanding their rights to self-determination in the form of launching their agitations in their respective regions so as to have their own separate administration or creation of state or union territory or autonomous hill state. In a way, it is mainly marginalization and discrimination in the hands of powers and riches that reign the government in accordance to their wish. As a matter of fact, tribals and indigenous people still continue to be the most backward sectors of the Indian society in terms of development paradigm, including educational and socio-economic spheres. The lifestyles of these communities have witnessed significant changes after independence compared to pre-independent era. This is mainly because of systematic and planned implementation of targeted interventions by the government. However, wide disparities still persist between the general category and scheduled tribes, as the areas predominantly inhabited by them in the country still remain undeveloped owing to various reasons, despite a number of initiatives taken up by the government for overall development of the communities. The development policies and programs are proclaimed to be more poor than ever. Several studies substantiate the disadvantaged position of the tribals, the indigenous or Dalits, and the poorest of the poor, destitute children and women, and distressed widows in particular, that arguably locates poverty, hunger, and distress in the context of structural deprivations accumulated over a period. It may be noted briefly that the problems of tribal and indigenous people are considered similar in nature to that of individual or group in terms of socio-economic, educational status, settlement area, governance system, politics, development or upliftment process, economic security, health and medical care, biodiversity and environmental consequences of all sorts, electricity, using and drinking water, and sanitation, work culture awareness, time and water management, reproductive knowledge and its do's and don'ts, transport and communication, appointment in services, and post and inaccessibility of social networks, lack of basic amenities, and awareness campaign including sense of value and their daily lifestyles are also concerned with them. Now we are going to take off prospects of rights. Tribals. As far as rights of tribals in India is concerned, it will be pertinent to keep in mind the two most important laws under the International Labour Organization about tribal people, that is Conventions 107 and 169. It may be justified that the tribals shall continue to enjoy their rights as well as discharge their duties and responsibilities in the same dimensions as they had contributed to the nation during the pre-independent era and even after independence as bona fide citizens of the country. The increasing number of population of indigenous people shall also attract the growing demand of their rights under the Constitution. Indigenous people. Any citizen residing in the country before pre-independent era was declared as indigenous people. Hence, whether tribals or non-tribals, whosoever have been residing in India before the attainment of independence shall be bona fide citizens as well as indigenous people. There are safeguards in the spheres of economy, social, and cultural rights of indigenous people. The right to self-determination, as enunciated in Article 3 of United Nations Declaration on the Rights of Indigenous People, has not also been recognized. The Indian government continues to perpetuate a policy of assimilation of indigenous peoples in developmental decision-making process. Although the ILO Convention 107 supported the adoption of UNDRIP, the ratification of the ILO Convention 169 is yet to be done. This is unfortunate. It has adamantly insisted that its own indigenous peoples cannot claim status or protection of them under these laws. The government rejects the very term indigenous peoples, insisting that all the Indians are indigenous and is therefore found to be hostile to any reference to the rights of indigenous people to autonomy, self-governance, or self-determination in India. It seems that government continues to adhere to an insidious policy of gradual demographic situation in the northeast by permitting a steady influx and settling of non-indigenous alien communities from Bangladesh, Myanmar, and Nepal. It is worth mentioning that 9th August in every year is observed as a Day of Indigenous People. This second international decade of the World Indigenous People is observed with the theme of a decade for action and dignity. The theme aims to highlight the importance of honoring treaties, agreements, and other consultative arrangements between states, its citizens, and indigenous people. Both indigenous and non-indigenous peoples have a pivotal role in making such global and regional treaties documents in their own communities by establishing new ways to live together, respecting one another, and in cooperating and coordinating in the pursuit of common goals. Now we have come to conclusion. Tribals and indigenous peoples should be allowed to develop along the lines of their own needs without any man-made imposition on them. Their rights on land and forest should be honored and respected. They should also try to build their own leaders for developmental works. There should not be any question over administration of these areas, and as far as possible, such efforts should also be made to realize through their own social and cultural institutions. And finally, the result of these should be judged not by the amount of money spent, but the quality of human character that has evolved. As the ultimate goal for promotion and protection of human rights is to understand the material and spiritual well-being of mankind, it is therefore said that the realization of happiness may fructify when we strive for it and rise above petty considerations. The Rig Veda considers the right to happiness as one of the fundamental rights of all human beings. So, it is a need of the hour to put on record that the right to happiness for tribals and indigenous people is to find a place in the acclaimed Universal Charter of Human Rights. It depends upon the governments how they look into the matter. At the same time, civil societies, NGOs, media, and others also need to stand together.